Thank you, Your Honor.
Counsel for Daniel Lewis.
Judge, Mr. Lewis is 21 years of age. I would submit to the court, Judge, he's not a threat to run from anything. He's a lifetime resident of the greater Boston area. He's one of 9 brothers and sisters. A number of his family members are present here today, Judge. He attended English High School in Boston, did not graduate. He's currently seeking a GED in one of the suburban communities in which he has been residing.
Where's that?
Well, it's Milford, Judge. And at the Judge, he's a young man that at the time he was at English High School, it's my understanding that he was a leader in the attempts to stop violence and drugs in the Boston schools itself, and was an advocate for that position. Judge, I would submit that he's currently, as I indicated to the court, he's currently taking GED classes in the Milford area. Judge, it appears from what the government has said that Mr. Bennett has presented here today that there were no eyewitnesses to the injury inflicted upon the young man that's now deceased, that others have said that they believe it could have been my client, and my client made some sort of a representation. I would submit, Judge, that one, he may not be the individual that inflicted the injury on that person. Second of all, the court certainly could consider this is a type of case that may not be felony murder, but rather could end up as some sort of an involuntary manslaughter. I think it's a type of case, Judge, considering the strong community ties of this individual. He has no other criminal convictions on his record, Judge. This is an individual who the court could consider some reasonable alternatives and consider even a bracelet for him. And I would ask the court to consider that type of circumstances for Mr. Lewis.
Thank you. Counsel for Mr. Jacobs.
Thank you, Your Honor. I'd suggest, first of all, that even on the Commonwealth's version of events, if the court wants to accept them for the time being, that Mr. Jacobs is by far the least culpable of the murder, of the defendants charged with murder. That is, he neither set it up, nor was he the shooter. He was, at best, he was there. Mr. Bennett's indicated that his statement to the police established all the elements. Well, I'm not convinced that his statement to the police did, because it seems to me that there's an issue that he withdrew, that he was getting out of there before the shooting. So there's a clear issue of withdrawal on his part. He has no convictions on his record. He has no defaults on his record. He has strong ties to the community. He's a recent graduate of Newton North High School. He lives in Newton with his mother and his sister. His mother and his father were both here in court with him to support him. There is no indication that he would go anywhere if he were to make some bail. I would ask the court to set a reasonable cash bail and such other conditions, including bracelet or whatever the court deems appropriate.
Thank you. Very good. Do you wish to be, with respect to Mr. Duarte?
I would just ask the court to agree with regard to the agreed upon recommendation concerning, without prejudice, the $20,000 cash bail on behalf of Mr. Duarte, with the GPS on the table to be sent to the official.
Very good. With respect to Mr. Duarte, I will set that bail with $200,000. He's going to show you $20,000 cash. He has to surrender that passport, but he's not to be released unless he's returned to the Waltham District Court, so that we can be sure that the bracelet's been properly imposed. That's the balance of the two defendants. They're both held without bail. Thank you, Mr. Counsel. You agree upon the date?
We have to.
Yes.
Mr. Jacobs, Mr. Lewis will be held without bail. Mr. Duarte will be released on $200,000 single surety and $20,000 cash. The condition of Mr. Duarte posting bail is that he surrender his passport to the probation department and that he be set up with a monitoring bracelet. All cases are continued to October 26th at 9 a.m. for probable cause.
Thank you, Your Honor.